If we could start right at the top at Mr. Adams' case, Mr. Morris Adams.
It's Mr. Goodrich's case.
Correct.
All right, so we're on the record in docket 25-01565. That is People of the State of Michigan versus Morris Adams. Oops. Will the parties please announce their presence for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the People.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Adams, who's standing to my right today.
And sir, you are Morris Andre Adams, is that correct? Thank you. This is the time set for a preliminary examination today. Mrs. L, how we proceed?
Your Honor, at this time, one of the necessary witnesses in this case is unable to be here today. The officer Mosby is in training with the National Guard until June 14th. We do have another officer here who would be able and willing to start the preliminary exam today. However, after speaking to defense counsel, it does sound like Mr. Adams is willing to waive his 21 days to have this adjourned for both officers to be able to testify on the same day.
Is that a fair statement, Mr. Goodrich?
Yes, it is, Your Honor.
May I inquire of Mr. Adams of his waiver of the 21-day rule?
Yes, Your Honor.
Mr. Adams, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Luke Goodrich, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a prelim within that 21-day period. You wouldn't be waiving your right to a prelim in general, just within that 21-day period, so that we could have both witnesses here to testify against you if need be. Is it your wish today to waive your right to a prelim within 21 days? Do the people also waive their right to a prelim within 21 days?
We do.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will reset preliminary examination a couple weeks. Mrs. O.
Yes, I believe that would be nice. If we could avoid the 20th potentially.
July 20th, right? Or June 20th?
June 20th. The officer Mosby will be back from training by June 14th, so we'd be good after that.
All right. So a prelim on the 27th? 26th? Okay.
How about 8:30?
Okay, we'll set it for preliminary examination on July. It's June, on June 26th at 8:30. All right, Mr. Adams, I've reset this for June 26th at 8:30. That'll be live on the 6th floor, just like we are here today, okay? All right. Anything else for the record in 25-01565, Mrs. L?
Not for the people.
Mr. Goodrich?
No, Your Honor.
All right, Mr. Adams, we'll see you on that June 26th date. Thank you for your time today.
Mr. Adams, I have a nice screen.
We have a, wait, who's next, Miss Gazelle? Thank you, Mr. Goodrich.
I believe we can head
You've
on
got a
to
couple more
Mr.
cases.
Goodrich's next case with Ms. Maldonado.
All right. Francesca. All right, so we're on the record in docket 25-01563. That is People of the State of Michigan versus Francesca Maldonado. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the People.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Ms. Maldonado, who's standing to my right.
And ma'am, you are Francesca Maldonado, is that correct?
Yes.
Thank you. This is the time set for a preliminary examination. Mrs. L, how we proceed?
Your Honor, at this time, the people's necessary witnesses have failed to appear. They were subpoenaed for today's date, and we have not had any successful contact with them. We have no idea why they are not here today. We do expect a motion from defense.
All right, Mr. Goodrich.
Thank you, Your Honor. At this time, the defense would move to have this matter dismissed.
Right, I'll have printed out an order of nollie pros pursuant to defendant's motion. All right, I'm in possession of a nollie pros order of acquittal on docket 25-01563, based on the prosecutor's people's unable to proceed because the complaining victim failed to appear, although subpoenaed, and there has not been successful contact with the complaining victim. The case is dismissed without prejudice, which means Ms. Maldonado, the people could reissue if they choose to, but realistically, for our purposes today, the case is dismissed. All right, ma'am. Right. There is a GPS, at least I have a GPS, that should be taken off in Mason, okay, probably at the sheriff's department. We will email the private entity, the GPS device, the one who put it on, said, let them know you're coming, all right? And then there's a no contact order and some other pretrial conditions. I'd give about 3 to 4 hours to make sure that's purged from the system. Carry this dismissal with you, just in case, all right? All right, I'll sign the order of dismissal accordingly, and then you can get a copy from my court officer. Anything else for the record in 25-01563, Mrs. L?
Not for the people.
Mr. Goodrich?
No, Your Honor.
All right, thank you. Thank you, ma'am. You're all set. Who's next, Mrs. L?
I believe we're ready on the Moore case,
Moore?
and then I do believe the AG would be ready on their case as well.
All right. Right, well, we have Mr. Goodrich here. Let's strike while the iron's hot. All right, so we're on the record in docket 25-01566. That is people of the state of Michigan versus Jaden Moore. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Goodrich.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Moore, who is standing to my right.
And sir, you are Jaden Moore, is that correct?
That's correct, Your Honor.
Thank you. This is the time set for a preliminary examination today. Mrs. L, how we proceed?
Your Honor, at this time, I believe there will be a waiver of the preliminary examination today. The people would like to place an agreement to hide a status on the record if the charge is pled to. That hide a status obviously will be agreed to until that first pretrial in circuit court.
Okay. So the terms of the agreement have been placed on the record, and it is open to the first pretrial in circuit court.
Correct, Your Honor.
Is that a fair statement, Mr. Goodrich?
Yes, Your Honor.
All right. May I inquire of your client, Mr. Moore, of the waiver of the preliminary examination?
Yes, Your Honor.
Mr. Moore, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Luke Goodrich, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case continue to circuit court. YTA is being offered in district court, and that will be open till the first circuit court pretrial. Is it your wish today to waive your right to a preliminary examination today?
Yes, Your Honor.
Mrs. L, do the people also waive the right to a preliminary examination today?
We do, Your Honor.
Yeah, I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I'll present the bind over documentation to the parties. Thank you, Mr. Biak.
I know.
He considers the one that we did the writ for, so it's not out, but he's not. He's out, so we didn't need the writ. Diego Terry.
Yes, he's out.
He's
So
out.
yes.
Thank you, Ms. Flavier. All right, so I'm on the record in docket 25-01566, and I'm in possession of the bind over documentation that is signed by all the parties. I'm going to indicate the examination has been waived on today's date, which is June 12th, 2025. Is there anything else to come to the court's attention before I sign the bind over documentation, Mrs. L?
Not the people.
Mr. Goodrich?
No, Your Honor.
I will sign the bind over documentation. Mr. Moore, your time in district court is done. You're off to circuit court. Will you get your next date to appear from your attorney, Mr. Goodrich? All right, sir. All right, Mr. Moore, you're all set. Thank you for your appearance today.
Thank you.
You any paperwork I need?
What's that?
I need any paperwork or anything for
You'll
you?
get, if there's any, you'll get it from Mr. Goodrich. I don't think there's any from the district court.
No, yeah, we're done. We're done in
All
district
right,
court.
put that in.
All right, thank you, Your Honor.
Thank you, Mr. Goodrich. All right, Mrs. Zell, where are we heading next? The AG case?
They are ready on that. I do believe that exam's going to be running.
All right,
Yes.
um,
Sounds like it should be brief.
All right, I think we've moved all four of the cases before it, so let's go ahead and, we'll go ahead and do that exam.
Gabby, I believe one of the attorneys just stepped out to do a PCC. I think for that case. I don't know.
Yeah, I can get him.
Okay.
I'm already on 3 of mine, Judge.
If we want to call one of those.
Let's go on Ms. Robinson's case. All right,
Do you want to do Harris first?
Yeah. Harrison Green already. I don't know.
all right. I'm gonna go on Harris.
Yes, please.
Yeah.
Then we set another file with the Harris. So we set the DV pretrial up on that date as part of it. So we have this is the felony file, and then I think we set the DV file also.
We did.
All right, let's go on the felony file first. So on the record in docket 25-01576, that is people of the state of Michigan versus Demetrius Harris. So the parties, please introduce themselves for the record. Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Mr. Harris.
And sir, you are Demetrius Harris, is that correct?
Sure.
Thank you. This is the time set for a preliminary examination today. Mrs. L, how are we proceeding?
Your Honor, at this time, the plea offer has been extended to the defendant through defense counsel. That offer is to plead to the count 3 in this case of the domestic violence and admit to the PA 53 no contact violation. Upon successful plea to the DV and taking responsibility for that no contact order violation, the people would be dismissing the remainder of the counts 1 and count 2, along with the misdemeanor file. And we would be agreeing to 7694A status.
And the PA 53 is in the misdemeanor file, Judge, just for the record.
So the plea offer is a plea to count 3. And that's the DV, is that the DV on,
This case, correct?
yeah. Dismiss. Super unsuccessful. Plea and sentence. There's an agreement of 769 for a status.
There is.
So that's on, and then in incorporating the misdemeanor file of 25031314. There's also a plea to the PA 53 violation. We'll do next. And then that case is to be dismissed. The DV on that case is to be dismissed.
Correct, Your Honor.
All right, so Ms. Robinson, my understanding is a plea to count 3, a killer of 769 for a status. Counts 1 and 2 will be dismissed upon plea and sentencing. There's a plea on the second file, which is 25-01314, plea to the PA 53 violation and a dismissal pursuant to continuing negotiations of that underlying file, which is 25-01314. Is that your understanding of the plea agreement, ma'am?
Yes.
All right. May I inquire of Mr. Harris of his misdemeanor plea jury trial rights?
You may.
All right. All right, Mr. Harris, you have the following rights in this case, and I'm going to walk you through them, okay? You have the right to be tried by a jury, to be presumed innocent until proven guilty. Now the prosecutor prove beyond a reasonable doubt that you are guilty. To have witnesses against you appear at trial. To question any witnesses that are brought against you. You're represented today by attorney Erin Robinson, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, Your Honor.
You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the misdemeanor domestic violence instead. Is it your wish today to waive your jury trial rights and plead guilty to the misdemeanor domestic violence case?
Yes, Your Honor.
All right. I'm gonna have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. I'm gonna bring your attention back, sir, to May 26, 2025, at the offense location of 1123 Ontario in the city of Lansing. Were you at that Ontario address in the city of Lansing on May 26, 2025?
Yes, Your Honor.
And who is Brittany Williams to you?
My former spouse.
Okay. You are pleading guilty today to offensively touching Miss Williams on that date and time that was not done in self-defense. So tell me, what did you do? What did you do to make you guilty of assault or an assault and battery against Miss Williams?
Your Honor, I was repetitively grabbing and yelling and throwing her down onto the ground and assault.
All right, and you did not do so in self-defense,
Correct, Your Honor.
and this was not done in accident.
Correct, Your Honor.
Anything towards the factual basis, Mrs. L.
No, Your Honor.
Ms. Robinson.
No, Your Honor.
I find the factual basis to be knowing, voluntarily, and accurately made. And then we'll refer to probation, really for the 769 for a status is what we're looking at. So probation is 1 floor down on the 5th floor all the way to the right. And they'll either see you today or they'll set up an appointment to see you, and they'll prepare a report, and then we'll see what options are available to us. All right. All right. The sentencing date will be set for
August 8th at 8:30.
August 8th at 8:30. All right, so we've set it for August 8th at 8:30 on file 25-01576. So that's all in the felony file. And then on file 25-01314, appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
And Ms. Robinson, are you also representing on this file?
I am for today, yes.
Okay. Appearance for the record.
Erin Robinson, Assistant Public Defender for Mr. Harris.
And then, sir, you are Demetrius Harris, is that correct?
Yes, Your Honor.
All right. This is the time set, and we alluded to this for a domestic violence and a PA 53 violation. This has been wrapped up into the felony file. That's my understanding of that. today, Mr. Harris, you're going to be pleading guilty to the PA 53 violation, a violation of no contact order. Is that correct?
Yes, sir.
All right. You understand you have a right to a hearing in this matter. You have a right to have witnesses brought against you. You have the right to an attorney. Ms. Robinson is here to represent you and to protect any rights concerning the pretrial order in this file. Do you understand that, sir?
Yes, Your Honor.
All right. I'll tell you the nature of the allegation is contact with Ms. Williams. And we'll give you a certain date and time. So is that the May 27th date?
It is, it's for the May 26th.
So there's contact with Ms. Williams on May 27th, 2025. Do you understand that, sir? You can have you raise your right hand. Do you solemnly swear affirm, tell the truth, the whole truth, and nothing but the truth
Yes,
under
Your Honor.
penalty of perjury?
Yes, Your Honor.
All right. So there was a pre-trial condition of no contact with Ms. Williams. This was done on May 5th, 2025, and then on May
27th. Oh, I'm sorry.
Yeah, the arraignment.
The arraignment was on May
May
5th.
5th.
Sorry.
No
Jumping
worries,
ahead.
No worries. And then May 27th, you were found to be in violation of that pretrial condition with having some contact with Ms. Williams. Is it your testimony today that you had contact with Ms. Williams after the May 5th date?
Yes, Your Honor.
Anything towards a factual basis on the violation of the PA 53, Mrs. L?
No, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, so we have the PA 53 violation. My understanding is there was a dismissal and the underlying charge of the DV. Is that correct, Mrs. L?
That is correct, Your Honor.
All right, anything towards allocution towards the PA 53 violation, a violation of no contact?
Judge, we just asked that it be set for the same time as the sentencing on that August 8th date, and we can just do everything together.
All right, Mrs. L, is that a fair statement?
That is fair, Your Honor.
I could set it is, we treat it separately, but that it can be set for sentencing on the same date. We have a date already. That is,
So we're not dismissing that file.
yeah, that's my understanding is that we'll leave the file open until that date. Which would-
That would be my understanding as well.
Okay, perfect.
So we wouldn't need a nollie process on that until the date of sentencing on the felony file. Let me read.
I just wanted to make sure I was understanding.
Yeah, no. So I will indicate that this case, the DV will be left open until, what's that date again?
August 8th at 8:30.
August 8th at 8:30. All right, and then we will set for sentencing on the same date. Once we get the report back, which is a good idea. Okay. Set for sentencing on August 8th at 8:30. Mr. Harris, just so you're clear, the PA 53 violation is treated separately as the plea on the felony file. It's a no contact order. So we're leaving the domestic violence file open, but we'll address both sentences at the August 8th date. All right, sir? All right. So go down to the 5th floor. They'll do a sentencing, a probation sentencing report on the felony file. So you're still under the pretrial conditions until sentencing. So what I'm saying is don't pick anything up, okay? You don't want to pick anything up pending because that's going to go in the report and then the report will be problematic. And there is a deal right now, but that deal, if I don't follow that deal or if I don't give YTA, you understand you could withdraw your plea. You understand that's right. All right. All right. Anything else for the record in 2501-314, Mrs. Allen?
Actually, yes, Your Honor. The complaining witness in this case has indicated that Mr. Harris works for her business, her personal business. And there was some concern about the no contact order and that working relationship. From my understanding, there hasn't been any direct contact through that relationship, but we wanted to bring that to the court's attention today.
Well, that's a problem, okay? Because I don't know how much work Mr. Harris does for Ms. Williams, but that's a good way to violate the order. Seems to me like it'd be a great setup to violate the order for you. And that's not good for you. So the no contact order is in place. You're not have any contact with Ms. Williams. And if it takes you, sir, for you to get another job or find another position, you would do so in protection of yourself. Because all it takes is one phone call from Ms. Williams to contact LPD to say, like, I've had contact with them, and that puts you under the microscope. And that's what we want to avoid. All right. And this being a two-file DV, we just want no contact, none whatsoever. So if you get to a Kroger and Miss Williams is there, you're to go the other way. If you get to your place of business and Miss Williams is there, you're to go the other way. Okay, there's a no contact order. And I'll leave the rest remaining to you. But I will tell you that most of the time, part of probation is to maintain and obtain employment. And if your employment needs you to work elsewhere, that might be a good idea. All right, sir. Mrs. L, anything else?
No, Your Honor.
I just want, right now, let's draw bright lines. Okay, let's draw a real bright line in order to protect Ms. Williams, in order to protect also yourself, Mr. Harris. Okay. All right. I will see everybody on August 8th at 8:30. Thank you for your appearance today. I think that's both files on that.
Yes.
Did you want to go on Robinson's, the rest of Miss Robinson's case while she's here?
We can, Your Honor. None of them are running, so she should be quick.
Good. She seems
I have a lot of the docket here today.
You do have a lot of the
As soon as I'm done
docket
here, then I
today.
could go elsewhere.
But we know where to find you, and you'll be elsewhere on this floor. But let's go on Mr. Crane, and then we'll go on
Mr.
Mr. Hopkins. All right, so we're on the record in docket 25-01363. That's people of the state of Michigan versus Chad Crane. Will the parties please introduce themselves for the record? This is up.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mr. Crane.
All right, and sir, you are Chad Crane, is that correct?
Yes, Your Honor.
Thank you. This is the time set for preliminary examination today. Mrs. L, how we proceed?
Your Honor, at this time, a plea offer has been extended to the defendant through defense counsel. That offer is to plead to an added count 2 of larceny under $200, which is a 93-day misdemeanor and or a $500 fine. And I can find the code for that in just a second here. That is under MCL 750.3565. There would be an agreement to pay restitution in the amount of $253 to Skymint, and I will fill out a pink sheet for the court, and an agreement to no upfront jail.
All right, so this is my understanding of the plea offer. There'll be an added count 2 of larceny under $200 pursuant to 750.3565. That is a misdemeanor, 93 days and or $500. There's a restitution agreement to Skymint for $253. And there'll be a pink sheet in that request. And then there's an agreement between the attorneys that you receive no upfront jail. If I was not going to follow that agreement, you'd have the opportunity to withdraw your plea. Do you understand that, sir? All right. Is that a fair statement, Ms. Robinson?
It is.
All right. All right, may I inquire of Mr. Crane of his misdemeanor advice of jury trial rights, Ms. Robinson?
You may.
All right. Right, Mr. Crane, you understand you have the following jury trial rights, and I'll read them for the record, okay? We'll walk through them. You have the right to be tried by a jury, to be presumed innocent until proven guilty, have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, the questioning witnesses are brought against you. You are represented today by attorney Aaron Robinson. She would be present at a jury trial on the misdemeanor to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, sir.
You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If you're pleased accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be having a trial. You'll be pleading guilty to the misdemeanor larceny under $200 count under the conditions indicated for the record. You understand that, sir?
Yes, Your Honor.
Is it your right? Is it still your wish today to waive all those jury trial rights and plead guilty?
Yes, Your Honor.
And have you raised your right hand? Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor, I do.
Will we be using the factual basis for count one?
Yes, Your Honor.
All right. So I'm going to bring your attention back to February 6, 2023 to August 2nd, 2023 at the location of Skymint, which is on Jolly Road in the city of Lansing. Were you working at Skymint during that time period in the city of Lansing on Jolly Road?
Yes, Your Honor.
And at that time, did you convert property or money to your own use that was actually for the use of Skymint instead?
I did, Your Honor, yes.
And it was initially charged as between $1,000 and $20,000. You don't dispute that, sir, is that correct? Okay. Anything towards a factual basis, Mrs.
No, Your Honor.
Anything for so I'm taking the factual basis for count one, for the misdemeanor count two, anything for the, on the factual basis concerning count twos, which is the larceny under $200, Ms. Robinson.
No, Your Honor, thank you.
All right, I find the factual basis to be knowing, voluntarily, and accurately made as to count one. We'll take it for count two as their larceny under $200. You have the pink sheet.
I do, Your Honor.
Did you want this referred to probation, ma'am?
I
Probably with the pink sheet.
think that would be best, Your Honor.
I think with the restitution, and it's more than it's 253, we'll refer to probation just on restitution alone to get that all set. Because they'll make sure that the restitution is done in order. There's also Killebrew agreement of no jail time. I have no reason why I would not follow that Killebrew agreement, because both lawyers have had the opportunity to see the CCH in this, which is your criminal history. But I'll look for recommendation from probation for that also. So there's twofold for sending to probation. One is restitution. The other is Killebrew no upfront jail. So we'll refer to probation. That's down one floor all the way to the right. Probation is there, and they'll either set up a meeting or they'll meet with you right now. Okay, and they'll do a report for me, and then we'll see what options are available to us at sentence. All right, sir. All right. So the sentencing date will be
August 8th and
August 8th at 9 o'clock. All right, I put the pink sheet for restitution in the file. And I'll see you on August 8th at 9 o'clock. Anything else for the record in 25-01363, Mrs. Allen?
Not for the people.
Ms. Robinson.
No, Your Honor, thank you.
All right, Mr. Crane, you're all set.
Thank
Thank
you,
you
Your
for your appearance today. Hawkins.
Yeah, that's fine. Just adjourn it.
You want to adjourn it?
Yes.
All
Yes,
right.
Your Honor.
I have to contact.
All right, so we're on the record in docket 25-01231. Is people of the state of Michigan versus Tashana Hawkins. Will the parties please introduce themselves for the record? Mrs. Allen.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Ms. Hawkins.
Is the time set for a preliminary examination today? Mrs. L, how we proceeding?
Your Honor, at this time, I believe both parties are asking for an adjournment here. A plea offer has been extended to defense. However, that plea offer does include an OWI charge that we are waiting for blood results to support. I have not gotten an update about those results, though I will be reaching out to the MSP lab today to see if I can get one.
So essentially waiting for some discovery or blood results on another file.
That's correct, Judge. Oh, it's on this file, but
Oh, it's on this.
unfortunately, the blood results didn't come back at the
All
time
right.
the charge was filed. So here we are.
All right. All right. And I would indicate that the defendant has waived her right to a prelim within the 21 days on May 15th. Mrs. L, are you waiving the appearance of Ms. Hawkins at our present preliminary examination?
We are, Your Honor.
All right. So we'll adjourn after the 21-day rule has been waived on May 15th. And we're, are we at 2 to 5, 2 weeks or 5 weeks? Then? Trying to, we,
5 weeks is better.
yeah.
Well, we have the 26th, which is
It's
2
a
weeks.
Thursday.
We have July 3rd, which probably nobody really wants to run an exam on.
The day before the 4th.
Yeah, and then we have week of the 7th and 4th is unavailable, so that would take us to 17th, I believe.
Is that the 17th or 18th?
18th.
That's fine with
July
me.
18th, does that work? All right. So we'll set it for July 18th. At what time? 8:30. For preliminary examination, the adjourned preliminary examination. That should get any discovery or blood results back. All right, so we've set it for July 18th at 8:30. Anything else for the record in 25-01231, Mrs. L?
Not for the people.
Ms. Robinson?
No, Your Honor.
All right, you should be all set. Thank you for your appearance today. Now we could do the AG case,
Yes, sir.
and then Ms. Donnelly has as the CSC, right?
Correct, Your Honor.
Okay.
Right, let's go on the Foxman matter, or Foxman, all right. All right, so we're on the record in docket 25-01122. That is people of the state of Michigan versus Vincent Foxman. Will the parties please introduce themselves for the record from the Attorney General?
Michael Trescone for the people.
Now, how do you spell your last name, sir?
Trescone.
Trescone?
Yes, sir.
And Jennifer Walker for the people, Your Honor.
And then can you spell your name for the record, ma'am? Jennifer
Common spelling, Jennifer, Walker, Walker.
All right, and for Mr. Foxman, appearances, please.
Yes, good morning, Your Honor. May it please report. My name is Michael Comorn, Komorn, Comorn, P47970. I'm appearing on behalf of Vincent Foxman,
Thank you.
who stands to my right.
And sir, you are Vincent Foxman, is that correct? Correct. Thank you. This is the time set for a preliminary examination today. And Mr. Trescone, how are we proceeding today?
Your Honor, at this point, the people are prepared to proceed with the preliminary exam, and I do have a few things to put on the record before we proceed.
All right, is there anything, what's that?
He needs to talk about our having opportunity.
I will speak up.
Yeah,
I'll project.
all right. Are there any, there's going to be a motion, or there should be a motion for sequestration concerning this preliminary examination. I will invoke a motion for sequestration, but the parties know the case better than I do. So if you see somebody walk in that shouldn't be in to see another person's testify, let me know and I'll invoke it. Otherwise than that, I'm not going to invoke the sequestration until you tell me, right?
Your Honor, our officer in charge is Detective Trooper Specialist Kaylee Berge. And we also had Agent Doyle listed as also an officer in charge, but I instructed him to leave the courtroom.
All right, and the investigating officer can stay during the preliminary examination. Anything else to come to the court's attention before Mr. Trescone, you start any preliminary matters concerning the sequestration?
No, Your
Mr. Kamor,
Regarding the sequestration only, or you're asking?
only the sequestration, and then we'll take the preliminary matters as they come.
No objection to how
All
the
right.
court has handled it.
All right, Mr. Trescone, you may proceed on any preliminary matters concerning the preliminary examination.
Your Honor, only that Mr. Kimura and I have discussed this case previously. We've discussed the procedure for obtaining a offer from my office, but there is no offer on the case at this time. And then the people have prepared a binder of our proposed exhibits. I've distributed one to Mr. Kimura, and if I may approach, I have one for the court.
Okay. And then I won't look at any of the exhibits until they're admitted and published.
Thank you, Your Honor.
I haven't marked anything.
They're all marked, or they should be.
So they're marked as exhibits one. Oh, I see.
Yeah, 2A, 2B. Yeah.
All right, so they're marked in the binder. And then I'll refer to them and then you can mark them again if you. That's generally how, that's generally how it's done. All right. And you provided Mr. Kamorn a copy of any exhibits to be used. Anything else, Mr. Trescone?
No, Your Honor.
All right. Mr. Kamorn, any comment on the binder? You've indicated your indication is you have received any copies of any exhibits that are going to be moved for the admission. Is that correct?
This morning, moments ago, before the court received the copy, I was handed a binder, which I think is the same. I haven't looked at it, but in terms of receiving that, as I just described, yes. But
All
I do
right.
have some comments.
Did you want to compare the court's binder to see if the court's?
I take brother counsel as well.
All right. Okay.
But beyond that, I do have some other comments.
All right. You go ahead, Mr. Kamorn. Any other comments concerning this?
Yes, Judge, as it relates to the introduction of any evidence, I'm making a formal oral objection. I can brief this issue if you needed to, but oral objection under 6.110D, which governs preliminary exams, the court is not to admit evidence obtained in violation of the Fourth Amendment, nor evidence seized in violation of Michigan's constitutional guarantees. The foundation for the search warrant in this case are all facially invalid. Some of them aren't signed, and the fruits flowing from those search warrants are inadmissible at this hearing. And we request exclusion of the evidence that's obtained and arose out of the initial 5 search warrants that were executed. I could identify what properties they were at. So the core rule specifically that I'm referring to, Judge, is 6.110D, except as otherwise provided in these rules, the rules of evidence applied to preliminary examination. The court may not consider inadmissible evidence in determining probable cause. Under the Fourth Amendment, Article 1 of Section 11 of the Michigan Constitution, no warrant shall issue but upon probable cause, supported by oath of affirmation, and particularly describing the place to be searched and the persons or things to be seized. And Judge, as I said, so I'm raising this issue because the facial invalidity and template use as described like Carson regarding the phones, the court is familiar with that case, phone searches and the issues regarding just template unlimited searching without any particularity or any nexus to the substance. It falls into that category.
So it's my understanding, Mr. Corn, that based on, there's exhibits that were based on a search warrant. And the search warrant you're indicating is an invalid search warrant or has problems with the search warrant, which would affect its Fourth Amendment status and not allow us to bind over on legally relevant evidence. Is that correct?
Because those things would not be admissible. In particular, there's a search warrant for the Michigan Department of Treasury.
Response, Mr. Tresco.
Your Honor, it sounds as though Mr. Comorn wishes to suppress the search warrants. The search warrants, most of them are over 3 years old. There is no motion before the court to suppress the search warrants or quash the search warrants.
I think there is now.
Well, and properly, it should have been a written motion that I could have responded to. My response on short notice is that a neutral and independent magistrate found probable cause at the time of the search warrants. And the court, for purposes of exam, has to presume that the probable cause was found by those judges. So I believe those search warrants stand for the exam, and the evidence obtained pursuant to those search warrants is admissible.
All right. Well, I'm going to give the motion stands, and I'll give the opportunity for both sides to brief the motion. I mean, that's where we had, because I can't bind over on evidence that's being challenged. And my understanding from Mr. Comorn's indication is that a lot of the evidence in the binder is being challenged based on a probable cause for the search warrant.
Correct.
So I will await a motion from Mr. Comorn. Response, we'll set up a response time for Mr. Trescone, and then we'll hear any motions concerning the exhibits. Once I've ruled on that, we can go forward with the preliminary examination, or we can set it for a hearing to go forward the examination. But I do believe that if there's no other report being used concerning an objection, it's essentially a motion to object to the search warrant. Essentially what you're doing.
And Judge, for procedural purposes, and I understand, brother counsel, I've had it happen both ways. Like I filed a motion, you can't file a motion for challenge the search warrant. So this is a formal objection, falls under the court rule that's in the preliminary exam. And it's not really, I mean, it kind of is, it challenges the authenticity and the validity of it, forcing the government to establish that it was seized pursuant to constitutional principles not being violated. Only then could the court, so that's the argument, but I'm fine to brief it, as I said.
Every court does it a little different, okay? But I don't want Mr. Trescone to feel like this is a surprise, like that we're all of a sudden, and that's what I think the AG is feeling right now. It was a little bit of a surprise because they haven't come with all the response correct in order. So let's set this. So we'll set this for a couple weeks for the motion, a couple weeks for response, and then a couple weeks in order for the court to see both. We'll have some rebuttal for the response, and then we'll set it out for an actual hearing date. If testimony is expected at the hearing, we probably should pick a date that fits with your schedule that allow like an afternoon of testimony. I think that would be the fair thing to do. Any comment on that, Mr. Trescone?
No, Your Honor.
All right, Mr. Comorn, you'd probably need a couple weeks for the motion. All right, so we'll do, the motion will be due to the court and and to the opposing party, and we'll set it for, today's the 12th, so let's set it for the 26th. So motion for, essentially it's a quash of the search warrant, but I understand the nature of the motion for bind over purposes. We'll set that for July 26th. Then we'll give 2 weeks for the response.
June 26th or July 26th?
It'll be June 26th.
Right. July 10th, I think.
Yeah, and then June 26th. I might have said July. And then July 10th for the response. And then we will set it for motion / preliminary examination to be heard. And that would be at the end of July. So that would be the 17th, 24th, or 31st, or Thursday or Friday. We switch here. So we do PCCs one day and prelims the next day. Let's give you a date and you can check your schedules.
Could we start with July 24th at 1:30?
July 24th at 1:30. First of all, does that schedule work with the Attorney General schedule?
Yes.
All right, Mr. Camoran, does that work with your schedule?
That'd be in the afternoon, 1:30.
Yeah, 1:30 in the afternoon. So July 24th at 1:30 in the afternoon. That's generally the hardest part, is making sure that all this lines up with schedule. So we have motion will be on June 26th. Response will be due by July 10th. And then we'll have the full preliminary examination / decision on the motion for July 24th. I'll most likely just say it from the record, I won't write an opinion. I'll just indicate it for the record on July 24th, and then the parties can go forward from there. Anything else for the record in 25-01122, Mr. Tresco?
Oh, Your Honor.
Mr. Camoran.
Just, should I feel the need, or does the court care if I would file a response to their response?
None,
Very good.
none. And I don't have any problem with that. And the parties can continue negotiations
For
through.
sure. The only other item was I did indicate to brother counsel that I thought there was one item that I had not received in discovery. He went and looked in his file, did not have a copy, so he sent it to me later, and I just want to ensure that part of the discovery that will be forthcoming, which was a tracking device search warrant, affidavit search warrant, is what I understood.
All right. And Mr. Trescone, you've had that conversation that discovery, Mr. Camoran's indicating he's not received full discovery, or there's still something out. And I'll leave that to your devices to contact Mr. Camoran and make that available. If that becomes an issue, just bring it to the court's attention.
Thank you.
It's fine, Your Honor. Thank
All
you.
right. All right. I will see everybody back here on July 24th at 1:30. Thank you, everybody, for your appearance.
Thank you, Judge.
Thank you, Your Honor.
And then Mr. Trescone, I'm going to return the exhibits because we'll
Can I have the
We'll lose
binder back? Till the actual exam.
Judge, do I have to get back the binder, or can I?
it's
How can I challenge the evidence better?
Well, it
Yeah.
might
have all the
change.
evidence.
I know, but I
Our
don't have it marked,
evidence
it'd be easy for me to refer to, you
It's-
know.
Well,
like-
our evidence might change
Well, let's-
based on
okay.
the motion.
let's go back on the record. So we're back on the record in 25-01122. So the record will address the binder. I would indicate that the binder is being taken back by the Attorney General. So I don't know what you would, you can only anticipate what motions would be made concerning the matter. So as a part of this, I would expect that you'd have to know what exhibits are being issued in order to make a motion to quash. Mr. Trescone.
Well, I should say that none of the items that Mr. Camoran mentioned in his motion to quash are in the exhibit binder. So I
Right,
don't
but
see.
he doesn't have the binder, so he doesn't know.
You can look at
He
it.
has all of the exhibits
understand,
and
but-
evidence
All
that
right.
we
Yeah,
submitted.
there's nothing in there that's not in what he received in discovery, so.
All right, so what we should do is, if this becomes a problem, Mr. Camoran should have at least a list of your exhibits, that your anticipated exhibits.
But there's a volume of discovery
Right.
material. I don't know what specifically they picked out. I mean, I can guess, and I'll tell you what, I find it odd that they're taking it back, and if they were gonna change the numbering, it's a numbering issue, we could adjust or whatnot, but I mean, if they intend to introduce those documents at the next exam, and there's more they can add to it, I should be able to take that, or at least, I mean, if they I mean, it doesn't make sense to take it back. I have this stuff already. It's not like it's hidden.
Right.
It's just got a label on it. So there's a solution here for other than me just giving it back. I just.
The solution I'm going to come up with is the Attorney General, before the 2-week period for your motion is due, you have to provide Mr. Trescone, Mr. Camoran, with a list of exhibits that you anticipate.
Your Honor, and I will, the cover sheet is the exhibit list.
Perfect. I was gonna see if I could take a picture of whatever they have there, just so I can see.
So if that'll work for your purposes, you know what's the anticipated exhibit list, and you can work from there. All right. All right. Anything else for the record in 25011122? We've had the list of exhibits transferred as an exhibit list, and we'll use that in order for the motion to quash, which will be due on June 26th. Anything else for the record, Mr. Trescone?
No, Your Honor.
Ms. Walker?
No, Your Honor, thank you.
All right. Anything else, Mr. Kimura?
But just if the list changed, they'll let me know so I can, and other than that, Judge, I appreciate your time and cooperation. Nothing else.
All right. If the list changed, let Mr. Kimura know, okay?
Of course, Your Honor.
All right. Thank you. We're all set. Thank you for your participation. Ms. Donnelly, you're here on Mr. Nathan's CSC case. I don't know if Mrs. Zell's here.
I'm right here. You can't see me, but I'm here.
There you are. Okay. And is Mr. Nathan here?
Yeah, he's out in the hallway talking about some.
We do expect a prelim today, correct?
Yeah, that's what I was hoping for.
All right. Let's take 10 minutes. I'll give the staff 10 minutes
Okay.
and then come get me when we're ready, and we'll go on the CSC prelim.
All rise.
Give me a chance to move around a bit. Make my physical therapist happy.
Be seated, thank you.
No, I'm not going that way.
Are you gonna shut that when you leave? Okay. So, I'm gonna have you to one of those are gonna be that just means that I expected else to testify in this case in certain form, we would have to ask them to make their own evidence. I don't see that happening to us. What can you testify with? No, I just do not want to do last night, but what I asked you when you were working at the time. So we'll do that and we'll compare it for stuff. Right, that, I'm going to ask you about the address of the hospital. I'll just tell you the address. Oh, okay. That's good to know. I can't remember any addresses. So, and then the date and time of it. I'll prep you for the date. Those are questions that I can do a little bit of leaving on the differences. Because we know the dates are going to be harder to remember than the actual. So then I'm just going to kind of walk you through. I'm going to ask you if you know. I'm going to ask you to identify them. So that's just basically to remember an article of clothing that you are in the future. You don't even have to look at it. I'm going to ask you to identify by an article of clothing. Okay? Are you okay? I'm going to tell you this now. If you get up there and you need a minute, please just ask for one. If you need anything, we are happy to stop. Court staff has waters and stuff. Judge is very kind and understands that you will likely need to make this. I thought the defense attorney is very nice, especially like transportation might get under your skin unintentionally. Yeah, their job, they have to do it. Luckily, this isn't a defense attorney. She understands this is not an easy topic. With that being said, I'm hoping that this is going to be a nice, quick, easy. All I have to prove is probable cause. Your testimony should. With that being said, I'm going to try to keep it very baseline. Like after you tell me how you knew him, that we get the date, time, and place established. I'm just going to ask I get that information out, I should be able to stop asking questions. I'll object if I feel like the house is coming at me for a reason. And if you feel overwhelmed by any hard questions or tons of questions, please just ask me. That really tried to do a little bit of space to breathe for a second. I know I just threw a lot at you. So, thank you. Yeah. I had Judge Rock up for the last time, so love that one. She did my swearing in ceremony for the bar.
that's very nice.
Yeah, and then Judge Flores, I mean, you never can say. When you do come up to give testimony, you're gonna. I'm going to do my best to stand between you and the defendant the entire time, so you can't even get doing that with the girl, so. If I can do anything to put myself between you and him, I'm still gonna.
I hate that. I saw him and I said, no, you're going first.
And then after your testimony, I'm just gonna have, like, once we say you're done, you can go. I'm gonna have you type right now. Building, I can give you a call. Yes, I'm just going to say. It's just, it's up to Judge. So, criminal sexual conduct to the fourth degree, that is a high court misdemeanor, so it's a 2-year misdemeanor. So I have to go through the process of that. For this specifically, we're not giving. For felony cases, we take it to the main prosecutor in our office and we say, hey, these are all the facts that I have. This is the case that I have. Tells us what we should do. We didn't want the offer in this. Nothing has changed to make me do it. And then based on the other, you asked me if we had done this specific case, right? So I do remember he had a different felony case, not how we got the justice. That felony case was not sexual. It wasn't assault. I believe he did get a felony. So that to the circuit court. So he was being. We want to make sure.
Yeah, you also, I left you a voicemail because you got your kind of late. I apologize. That's where I am with that. That's the part.
Oh, you're trying to.
It's just me. I'm trying to catch up.
There you go. Yeah, no, not a problem. You guys made it on time. Honestly, we could have waited after you got that voice, after I got the voice.
Oh.
So that's super helpful.
Okay. I was like, please don't let me be ready at 9 o'clock.
No, this is this is slightly a different part than other parts of this. I get a little bit of grace to call the docket, so cases that are ready, cases that we need to wait a little bit on. That gives some defendants time to show up when they're running late.
Have we ever started this exam?
No, we have not. He had a different case that.
Is that what I'm thinking about?
I think so. I'm not sure. That's a good question. Yeah, I'm not sure. He probably did recon them for his felony file. I know his sentencing for that is not until July. So unfortunately, we have not been sentenced in that case. He's probably not. I'd double check that information.
I have buddies
Oh, okay.
so if he needs to be picked up.
Well, he is here
I can
today.
manage.
So.
I think your con witnesses.
One, yes. I don't have any exhibits for today. So I'm hoping it'll be nice and quick.
That would be nice, because otherwise it's going to get very unpleasant for us this afternoon with no fan.
in docket 25-01551. That is people of the state of Michigan versus Tyrone Nathan Senior. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Donnelly.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Tyrone Nathan Senior, who is standing to my right.
And sir, you are Tyrone Nathan Senior, is that correct?
I am, Your Honor.
Thank you. This is time set for a preliminary examination today. Mrs. L, how we proceed?
Your Honor, it's my understanding that we are going to go ahead and proceed with that preliminary examination.
All right. So I will invoke the sequestration order, so no witness should watch another witness testify. Both litigants know the case better than I do. So if anybody comes in during the process, just let me know. We'll make sure that one witness doesn't observe another witness testify. Anything else, any other preliminary matters to come to the court's attention, Mrs. Zell?
Not for the people.
Ms. Donnelly.
Not for defense.
All right, Mrs. Zell, you may call your first witness for the preliminary examination.
Thank you, Your Honor. At this time, the people call Adriana Shaw to the stand.
All right, Ms. Shaw, you can come up here and stand right in front of me. And please spell and state your first name and your last name for the record.
Adriana Shaw, ADREANNASHAW.
All right, please raise your right hand, ma'am. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, go ahead and have a seat. The microphone goes right to the court recorder's ears, so please project as best you can. And Mrs. L, when you're ready.
Thank you, Your Honor. Thank you for being here today, Ms. Shaw. And I just want to start by taking you back to 2023. At that time, were you working at Sparrow Hospital?
It was capital cardiology, yes.
And what was your position there?
I was a medical assistant.
Okay. And do you recall working on May 1st of 2023?
Yes, I do.
And do you happen to recall what day that was?
I believe it was a Monday, if I'm not mistaken.
And on that day, do you remember seeing a patient by the name of Tyrone Nathan?
Yes, I do.
And would you be able to identify him again if you saw him again?
It's in the blue shirt.
Thank you. At this time, Your Honor, we would ask that the identification of Mr. Nathan be entered into evidence for the purposes of prelim.
Right, you were indicating that it's the individual to the blue shirt that's next to the woman in the striped shirt with the green.
Yes, sir.
Right. Any objection to the witness identifying the defendant for purposes of preliminary examination, Ms. Donnelly?
Just, Your Honor, that I want to make sure that Ms. Shaw is actually looking or can see not looking, but can see him because she's kind of back. I just want to make sure she's looking at, she can give full view of him before she answers that question.
All right. Did you have the opportunity to see Mr. Nathan?
Yes, I see him
All
right
right.
now.
All right. Any objection, Ms. Donnelly?
No, Your Honor.
Okay. So that understanding, the witness, the preliminary examination will reflect that the witness has identified the defendant.
Thank you, Your Honor. Now, Ms. Shaw, on that day, do you remember why Mr. Nathan had come into the hospital?
He was coming in for a follow-up appointment.
And at that time, what were you doing in his care?
I was getting vitals and an EKG on him.
While you were doing that, what was going on?
He had told me that my shirt looks really soft, and then he turned around and grabbed my butt.
And when you say that he grabbed your butt, can you tell me what side did he grab?
My right side.
And do you recall what hand he used? No? Okay, that's okay. And at that point, how did you respond to that?
I am not gonna lie, my flight or fight response kicked in and I kind of froze. And at that time, he also grabbed my right hand and tried to put it in his groin area.
And when he did that, how did you respond to that?
I ripped my hand away and tried to get out of the room as fast as possible.
And at any point, did you? And were you able to get out of the room?
I was, yes.
And after you were able to get out of the room, did you go tell anyone?
I went to another room. I had told my coworker that I needed a second, and then I called my significant other. And then I had texted said coworker and told her what had happened. And then my manager had come in at that point.
And did you report this to the police right away?
I was told my employer had to talk to his lawyers first, so I waited 2 days.
But you did end up making a
I
police
did make
report?
a police report.
Thank you. No further questions at this time.
My only question is, you indicated this happened while you were at the hospital. What's the address of that?
1200 East Michigan Avenue, Suite 725, Lansing, Michigan 48912.
Any questions concerning the follow-up question, Mrs. L?
And then just to confirm, that's in Ingham County?
Yes, ma'am.
Thank you. No further questions.
All right, Ms. Tomlin, cross-examination.
Thank you, Your Honor. Good morning, Ms. Shaw. Thank you for being here today. So it's your testimony that you were working as a medical assistant at Capital Cardiology when this occurred?
Yes, ma'am.
How long had you been working there?
At that time, I had been there for about a year and a half.
And was that as a year and a half as a medical assistant?
At that facility, yes, ma'am.
Had you ever seen Mr. Nathan before?
No, I have not.
And you said that after you left the room, you did eventually report this to other people.
Yes, ma'am, my coworker.
You said that it was, you said you texted, you tell your significant other,
Yes, ma'am.
you told your coworker, and then you told your manager,
Yes.
Yes,
Thank
yes,
you.
sorry.
and then you told your manager.
Yes.
All right. Did you ever see Mr. Nathan after that?
I did not know.
Do you know what happened to Mr. Nathan after you left the room?
Personally, I do not know. From what I was told is that he was told to leave, and he did.
When you were in the room, you said that you saw he grabbed your butt, but you don't know with which hand, right?
Correct.
Were you looking at him when this occurred?
Yes.
Okay. So, would it be fair to say that he had to reach around to grab?
I was standing fairly close to him, but yes, he probably reached around a little bit.
All right, and could he have been like could it have been like where he was like you were facing him, but he was kind of like to the side or an angle or something so that he might not have had to like reach far, is what you're saying?
Correct. Yes.
Okay, all right, because you're not exactly sure about the orientation. You know that you saw him, right, when he did it?
Correct.
Okay. And then how long after that until he grabbed your hand?
It was almost instantaneous.
Would you say, do you know if it was with the same hand?
Yes.
And then you said that how long after that until you were able to leave the room?
I'd say approximately 45 seconds.
All right, so you said that, so for like 3/4 of a minute, you were still in the room with him after he had grabbed your hand?
Yes, I had to grab my stuff and get out of there. I was
Okay.
not going to leave my laptop with patient information in the room.
Okay. Anything else happen in that time?
No.
Okay. All right, no further questions, Your Honor, thank you.
Any redirect, Mrs. L?
No, Your Honor.
All right. May this witness be excused from the people.
She may, Your Honor.
May this witness be excused from the defense, Ms. Donnelly.
Hold on, I'm sorry, Your Honor. Is there, I'm sorry, can I ask, I guess, one more question?
Yeah, and then I'll give Mrs. L
Yeah,
to
Tom,
redirect on the
to
question.
redirect, yes. All right, I'm sorry, Ms. Shaw, are you still employed at Capital Cardiology? Yes, or no? You don't have to explain
No.
it, no, okay. And, were you in, I'm sorry, and when did you leave the Capital Cardiology?
Within the last 2 weeks.
Only within the last two, so, okay, you were working up there until the last 2 weeks?
Correct.
Okay, all right, thank you, Your Honor.
Any redirect based on the single question or double question or two questions, Mrs. L?
Just briefly, Your Honor, Ms. Shaw, was your reason for leaving in any way related to this incident?
No, ma'am.
Thank you. No further questions.
All right. All right, may this witness be excused from the people?
She may.
Ms. Donnelly.
Yes, Your Honor.
All right, thank you for your appearance today, ma'am. You're excused. Any further proofs today, Mrs. L?
No, Your Honor, at this time, the people rest.
Any proofs today, Ms. Donnelly?
No, Your Honor. Yeah, no, Your Honor, I don't have any witnesses or exhibits.
Thank you. Motion for bind over, Ms. Azal.
Thank you, Your Honor. At this time, Mr. Nathan is in front of you today facing a charge of criminal sexual conduct in the 4th degree. This is a high court misdemeanor of 2 years and or a $500 fine. At this time, the people had to prove by a probable cause standard that the defendant did intentionally touch Miss Adriana Shaw's buttocks, and that his acts could be reasonably construed as being done for sexual arousement or a sexual purpose. Today, Your Honor, you heard from Ms. Shaw, who described that her left buttocks was grabbed by Mr. Nathan while she was trying to help perform some introductory medical tests for his appointment. At that time, she froze a little bit and then her hand was grabbed and started to be moved towards his crotch. At this time, Your Honor, we would ask that this be bound over on the CSC 4th degree charge, as Mr. Nathan did intentionally grab Miss Ariana Shaw's buttocks, and the totality of the circumstances do indicate that this was likely done for a sexual arousal or sexual purpose, as he pulled her hand to her crotch, asked about the material of her shirt, made comments about that. And we would ask for it to be bound over as such. Thank you.
All right. A response to the motion for bind over of Mrs. Donnelly.
Thank you, Your Honor. Simply put, we'll just remind the court about the burden of proof here. That is the prosecutor's burden to prove with a probable cause that, you know, the elements of the offense did occur in this case, that the defendant did intentionally make contact with a part of a person's body, like that being a genital area, groin, inner thigh, buttock, or breast. And secondly, that it was done for sexual purpose or could be reasonably construed to have been done for sexual purposes. Obviously, this testimony was very simply put today, but we want the court to consider all that was said in regards to probable cause. Thank you, Your Honor.
Thank you, Ms. Donnelly. All right, so the standard for preliminary examination is probable cause. Probable cause being the second lowest standard in criminal law, the lowest standard being reasonable suspicion. I find that by probable cause evidence that this all occurred on May 1st, 2023 at the location of 1200 East Michigan Avenue in the city of Lansing. So that I find by probable cause evidence, location, venue, and date have been made. Identification was made by the witness, identified the defendant in court today. And so location, venue, ID, and date have been made at a probable cause evidence. And then the Ms. Shaw testified, and it was the single witness who testified that she was working that day, treating the defendant, Mr. Nathan, and that Mr. Nathan, during treatment, did reach out and touch her on the buttocks. That by itself appears to be an assault and battery. He said, may or may not have, I can't remember what he said, but then she did indicate on the record today, she testified that he then grabbed her hand and placed towards his groin area, which would identify as being as more than enough evidence to reasonably construe that Mr. Nathan did this for a sexual purpose. And therefore, I find the offense elements of criminal CSC fourth to have occurred, that the defendant did engage in sexual contact, that is touching of her buttocks area with Ms. Shaw, using force or coercion to accomplish the sexual contact, contrary to the law of the state of Michigan, and that it's done for sexual purpose would be indication of the follow-up, which was to grab the hand and then to place it at her groin, at his groin area, which could be reasonably construed for sexual purpose. I find that is enough evidence to bind over concerning location, offense, venue, ID, and date. And I will bind over, so I will indicate for the record that the examination was held on today's date, which is June 12th, 2025. It's found that probable cause exists to believe both that an offense not cognizable by the district court has been committed and that the defendant committed the offense. And I will bind this over as charged on count one. On count one, which is the CSC fourth. So, Mr. Nathan, your time in district court is done. You're off to circuit court, where you'll get your next date to appear in circuit court from your attorney, Ms. Donley. Anything else for the record in 25-01551 before I sign the district court bind over Mrs. L?
Not for people.
Ms. Donley.
I'm sorry, Your Honor. No, Your Honor, thank you.
All right. You'll get your next date from circuit court from Ms. Donley. You should be all set, sir. Thank you for your prayers.
Thank you.
Did you get the transcript?
Yes, please. I would.
All right, at 1:30, there's Cervantes. And he has the Nichols Law Firm. So he's got some arraignment on other charges, but we're okay. They can attend by Zoom. I think they're going to be requesting an adjournment.
Yes.
And they're going to be, I'm assuming that they're requesting an adjournment. And then we have Lindsay and Terry as the last two.
Correct.
I haven't seen Mr. Palmer. I did see Mr. Carter earlier.
Yes, I have heard that Mr. Palmer will not be coming in today. I do believe, from what I've heard, Mr. Watson will be covering for that case today.
Okay.
And then from Mr. Carter, I heard hopefully his client appears. Is where we're at with that.
Okay. All right. Well, we'll wait and see who shows up for that.